it's really treating your spouse as if they were like an animal, in the sense of to be like a dog, to be trained to obey your commands, and then punished if they don't. Hello, welcome to the next episode of Beneath the Law. Gavin Tighe here with Stephen Thiele. Stephen, how are you today?
Thumbs up, my friend. How are you doing?
Good. It must be spring. We're both wearing fuchsia shirts. So I don't know what that was planned or.
Well, and I don't know. We didn't coordinate that this morning.
Yeah, it must be summer, or else you can't wear fuchsia. That's one of the rules of fashion, as far as I know. You can't wear fuchsia in December, absolutely not. Unless you're in the Bahamas, I suppose you can wear fuchsia all year round.
I don't know. I just thought it's a good looking shirt, and
Matches your eyes.
We're streaming. Yeah, my green eyes
matches my forehead while I'm going purple. Come on, stressing out about every case that we have. In any event, the law is a ever changing, and ever growing, and a living thing, as they say. And today, I guess we're going to talk about a new tort, not arising, as many torts, I must say, don't, out of the most pleasant of circumstances, but a new tort that has emerged from the Supreme Court of Canada, the new tort of what the court has referred to as intimate partner violence, as being a new cause of action that is capable of sustaining a claim by I suppose, injured would be one way to describe it, or a spouse who has been the subject of intimate partner violence, and what that means within the context of the tort, and can now sue their I suppose former spouse or partner for those actions.
Yeah, it's a new remedy that is provided. No, it was just kind of before we got on air here, looking at the amount of money that was awarded in this case, and it's not a tort that's going to necessarily produce a huge amount of a monetary award. I think the lady here in this case, the former wife, got a total of $150,000 for the abuse, coercion, and control of her husband. But certainly a groundbreaking or landmark decision that is going to have, I think, Gavin, a lot of ramifications within intimate partner relationships. There are some cultural issues, I suppose, that may impact this kind of a case, but a huge case for women's rights in particular.
Yeah, I mean, I think, in fairness, it does primarily affect women. I mean, women are obviously disproportionately the victims of intimate partner violence in male-female relationships, simply because the male theoretically has the physical ability to abuse the spouse. And I think also but I think the court went a little further than the usual sort of actual violence, in the sense of assault. I mean, I think the court went further than that and went into what I'll call as mental abuse of overt control or controlling behavior that effectively dehumanizes the spouse and makes them a victim, very much, even above and beyond physical violence.
Yeah, and I think in that regard, the word violence may be inappropriate in terms of the naming of the tort, because, as you say, it doesn't necessarily, as far as I can tell, require any kind of physical violence. And that's part of the reason for the creation of the tort, because if it was physical violence that was being compensated, that would fall under assault in
Right.
general.
Right.
Right. But we're looking at more subtle forms of coercion or manipulation by one spouse over the other, in terms of some form of, controlling behavior, whether it's some form of mind control or just behavior such that the other spouse it lives in fear, basically, afraid to go out and get a job. In this case, the husband prevented the wife from traveling for her mother's funeral. So it doesn't necessarily require, as far as I can tell, a physical act of abuse of the dominant partner against the one that is, basically subversive in the relationship.
Right. I mean, I think that is the point where the law tries to address, as we grapple as a society, and law being, as I always say, the fine print of the social contract, trying to grapple with, as we gain more understanding of the wrongs, which are what torts are, that people can do to one another. And it's much more than, just hitting somebody or what have you. It's really this complete, as I suggested, is the dehumanization of the spouse, into the sense that the spouse becomes the property, for lack of a better word, of the other, and the complete control of the other, with no autonomy or free will of their own. And their ability to live their life, uh, you know, as they choose to, has effectively been taken away through complete control of the spouse.
Yeah, and so that's basically what we're now looking at. That you know hits on issues like a loss of dignity, loss of equality, within a intimate partner relationship, whether that's a marriage or a I would tend to think that it's a long term spousal relationship, because that's really what this new tort, is meant to capture. It's a long standing pattern of abusive or domineering behavior by one spouse versus the other. It's not a one off or a two off or kind of tort that the court is concerned about. It is a long term pattern of abusive conduct.
Right. I mean, I think that, as I struggled with this a bit, because I think what we've got here is, in many instances, and I mean, maybe this is just my own perception of it, but traditional marriages in a lot of cultures, particularly cultures where the male is seen as very much the head of the family and the head of the household, and to be obeyed by the wife. This type of tort really might conflict with a lot of those value systems that are not necessarily Canadian or Western value systems, but maybe the value systems that are traditional in places where many people come from. And we're dealing with a lot of cultural sensitivity issues in respect to that, and ways that traditional marriages are viewed within very a great number of societies. And here we have that, what would be seen to be, in many senses, at least superficially, to be this control or domination by the male in the partnership, as being seen as tortious abuse.
Yeah, and just by way of background, this couple immigrated to Canada from India, right? So they're not of a European cultural heritage. You know, that said, there are certain European cultures as well
Yeah,
where
that's for sure.
where where where,
Yeah.
where the males
India
look
has no monopoly on misogyny, that's
exactly.
for sure.
So and there are certain religions as well, Gavin. Where you still see, I drive when I drive up north. There's a I don't know what it's called in terms of the term for the what would be a church, but it has a male and a female entrance.
Right. No, that's very, very common. I mean, there's many religions, that very much do not mingle male and female in worship. I mean, a great many religions. I guess the issue becomes is whether or not that becomes domination to the point of tortious dehumanization, at a certain point or not. I mean, to be it's a very interesting kind of intellectual question and esoteric question. If people choose that life, are they making a free choice? Are you free to choose that? Is the choice of that life, in and of itself, a consent to it? I'm going a little bit beyond the topic of what the tort was talking about. Obviously, the particular situation here was abhorrent and was not something that the wife was consenting to in the normal sense of the word, because her ability to consent was kind of being suffocated by the dominance of her husband. But I suppose the issue, I mean, one of the aspects of free will is one can choose to give up one's free will, and that's an exercise of free will.
Well, look, if just as we're talking about it here, though, from a cultural sensitivity standpoint, or even a religious viewpoint, certain practices certainly, are not necessarily equal as we would see them in a well-developed society of
Well
equality,
developed in our
right?
view.
That
It is a bit of a
right,
cultural,
exactly right.
ethnocentric,
Like,
culturocentric view. I mean, I think that, but this is Canada. This is the Supreme
but it's
Court
a
of Canada.
it's a paternalistic view in
Sure.
some respects, right? Right. My paternalistic view is that everybody should be equal, but certain practices of other cultures or certain religions, by their own definition, have an unequal framework. And so, how are those cases going to fit within this new tort if I lead expert evidence? Well, this was the religious practice, or this was the practice of the culture. There was no expectation of having all of these
I
freedoms.
guess the question becomes is, I mean, to me, if that's that's something that you were born into, that's the culture you were born into, and you really didn't have a choice as to whether or not that was the way that you were going to live your life, and then your life was sort of set from that moment forward, and you were, I mean, that's just, you were married off into that arrangement without any free will or not. I think that's a fundamentally different situation than someone who chooses, for example, to convert to a religion and adopt that way of life. Um, which I mean, I'm reminded of Milton's words, "Then servitude is perfect freedom." But I mean, we're really getting beyond the concept of the tort, which is to say that clearly this spouse did not consent or agree to this, and her ability to consent or agree had been effectively taken away from her.
Yeah, 100%. And look, it's unfortunate in terms of not all family situations are necessarily the rosiest, of families, and they don't necessarily paint rosy pictures. And here's the court having to deal with a situation that was simply beyond the existing torts of assault and battery or intentional infliction of mental harm, in terms of the practices that were being carried out by the husband and that the court accepted that the husband was placing against the wife.
Yeah, and I think it recognizes that there is beyond the usual damages that occur, that there is damage and harm that must be addressed, that is potentially not has not been recognized appropriately in the prior torts. As you mentioned, assault. I mean, look, if it's a spousal assault, it's an assault, and the tort of assault would theoretically cover the physical injury. I think what we're talking about here is the court recognizing the larger harm, and it reminds me of other torts that the court has created new causes of action that didn't really exist before. I'm thinking of like the intrusion on seclusion is an example of that, where it's like you have a reasonable expectation that your information would be personal and private, and someone breaches that invasion of privacy notion, which is a wrong. I mean, there's harm to that. There is a loss of confidence in the system. There is a loss of trust. There is a harm to the victim of that situation. I think in that case involved a bank employee who was going through records of his of their partner's uh, uh, affair, or girlfriend or something, and going through their bank records, and there was a suit then against the bank and the bank employee for allowing that to happen. And those are new causes of action that didn't exist before, but the harm is real, and the law is alive, and as a living organism, it grows to address harms as it recognizes them.
Right, and look, I mean, exerting financial control over someone or preventing someone from getting an education, they don't fit within those torts. So in terms of legal aspects, sometimes people complain if we don't highlight what the test is or get into the meat of the law. So just I think quickly here, in terms of this new tort, it consists of three elements. Basically, the plaintiff has to demonstrate first that there's abusive conduct within an intimate relationship, and that's important. So not any other kind of relationships are captured by this. It has to be an intimate partner
Well,
relationship.
what does that mean? I mean, what is the parameter of that in terms of the tort? Is that like would a parent child relationship be considered that, or is it spousal?
No,
Is it
because that wouldn't be an intimate relationship.
so it has to be? Is it a sexual relationship?
I yes, I think it has to be that,
Okay, okay, that's
or or
interesting.
anything that is close enough to being falling within the definition. Who knows? I mean, there may be some push on the scope of what
No, but
that definition should
you
be.
can there's tons of relationships where you can see where one party is sort of the dominant, that the overly domineering partner, and not necessarily sexual relationships. I think parent child would be common,
Right,
where
but
they're
I
controlling the
think
purse
that's
strings, and they're to a point where either you do what I want or else.
I think that's facts for another day in terms of
Maybe
another
the torts
case.
are going to be growing.
Well, but the Supreme Court of Canada left that door open. When you think about the original case at trial, the judge actually had the tort as being one of family violence. So the parent-child relationship would have been captured
Yeah,
within that tort.
yeah, that would be even one of even more dependency. I can't think of a relationship more dependent than parent and child, particularly for a young person who's completely dependent on their parents.
Yeah,
Um,
and there's a lot of vulnerability in a parent-child relationship in terms
Absolutely.
of, when there's a marriage breakdown, there's undue influence or undue influences that can be exerted by a parent on a child. That is left for another day. But Gavin, I can certainly see if the Supreme Court of Canada is recognizing this tort for intimate partners, it could certainly in the future be recognizing a tort where a parent basically is dominating the child in such, again, coercive way that leads to suffering or a child living in fear of their parents.
I mean, I think that all of these torts, as far as I can tell, I mean, when I think about all of it, it really depends on power and the misuse of power and the overexertion of power to the detriment or harm of the party over whom control is exerted. And ultimately maybe that's just the answer. I mean, and it extends to all sorts of relationships, fiduciary relationships, for example, in the commercial context, where one party has control or power. I mean, with great power comes great responsibility, as the saying goes, and therefore, in this particular instance, if you take power away from another improperly and utilize it for, you know, wrong purposes and causes harm to that individual, I think that is ultimately the court is going to find a way to recognize that, whether it be the creation of new torts or otherwise.
Before we had the sidebar, um, the domineering spouse has to have intentionally engaged in the conduct at issue. Um, and then the third element is that the conduct has to fall within the view of the court that it's some form of coercive control. And that's basically an objective kind of assessment by the court, and it asks the question of whether a reasonable person would view the pattern of behavior as being coercive and harmful to the plaintiff's freedom, dignity, and equality. So those are the three elements of the tort in a nutshell.
Right. And, I really think that the bigger, the large, I mean, this is obviously an important, um, recognition by the country's highest court, of this type of harm and the need to address it. Again, the level of the odiousness of the conduct and the remedy seem a little out of whack from where I sit. I don't know, $150,000 is a lot of money, but it's really not a lot of money in the context of this is an intentional tort. This is an intentional wrong. This is akin to, you meant to hurt this person in respect of what you did, and I would think that the level of damages should, reflect a rebuke of someone who intends to harm another person, through insidious means here, which is sort of this mind controlling domination that dehumanizes their partner, which is really quite awful. I mean, I did. We talked about before the broadcast. It's really treating your spouse as if they were like an animal in the sense of to be like a
Yeah, a
dog
form of
to
property.
be
Right.
trained to obey your commands and then punished if they don't. I can't think of anything more dehumanizing than that, and that should invoke the court's censure, in my view. But in any event, $150,000 is not nothing, and it is a lot of money. I don't know what the means of this particular family were, but it is important. But I think the bigger issue here is that the common law has often been referred to as a living tree or what have you, and other lots of analogies. But I mean, the common law is constantly one of the reasons why it has been such a successful form of law throughout the world is that it is ever growing, it is ever changing, and it is capable of pivoting and embracing new aspects, new technologies, new means of addressing through the court system wrongs done to others. I think this is just the latest example of that.
Yeah, but at the same time, Gavin, it's a lot of courts are extremely hesitant to adopt new torts. Even in the history of this particular case, the Ontario Court of Appeal overturned the trial judge's decision and found that the existing courts were flexible and capable to capture the harm that was done to the spouse in this case. And, so we don't necessarily see a lot of change to the common law. As you mentioned, we've got the privacy tort. We have now the other tort of, sharing intimate images that can lead to damages, right? Disclosure of private facts, I think, is that tort. And about 20 years ago, the court developed the negligent investigation by police as a tort. Where you had malicious prosecution first. Now they added that tort. So it does change. It's incremental change, but you have judges who sit on our benches that are extremely hesitant and say that if there's supposed to be any kind of change, incremental or not, it's up for the legislature to make those changes. Frankly, I don't see how in this kind of context, Gavin, the government should be legislating, a remedy for intimate partner violence. That's
No, but I mean, a lot of legislation flows from the codification of the common law in the sense that initially torts or what have you are brought up by the court through the development of the common law, and then those torts are codified in legislation subsequently. I mean, it's not that's not an unusual evolution of how our laws develop and how our legislation develops. So I don't see that as a problem. I think that there has to be flexibility. At the same time, there has to be predictability. I mean, I think that it's a fair comment from judges to say, is there precedent for that? Because I mean, I think that the reality of it is, I'm not talking about this situation particularly where we're talking about family law situations, but in all sorts of other situations, commercial situations and whatnot. Courts will often ask for precedent because parties need to govern their affairs and their lives, with an understanding of what's onside and what's offside, and I mean, some predictability in terms of what the court will do is important I think, in terms of how people and how certainly businesses govern themselves. So, I think that there's always that balance between, innovation on the bench and, some certainty in terms of what people can expect when they get to a court. It can't be a free for all, sort of like, well, the judge can do whatever they want. parties are entitled to have some expectation, I think, of what is likely to occur.
No, and look, in fairness to the Supreme Court of Canada, it sets some guidelines as well as to when a judge should, make a decision that results in a incremental change to the common law and results in a new tort. Look, I think this case is going to have some very interesting ramifications. We haven't seen them yet, but our court system is already bogged down.
That's just what we needed, another cause of action.
Right. So now we've got another cause of action in, look, let's face it, very acrimonious and contentious area of law in terms of family law. You're now adding another cause of action. How long does, how much more time will be added to trials to deal with allegations of intimate partner violence? And I'm not suggesting that those claims should not be made, but I think governments have to look now from the other end, and we've had this complaint for a long, long time. Now we don't have enough judges appointed to the bench to deal with ever expanding litigation, and there's lots of delays in litigation, and so I think governments really need to seriously look at appointing more judges to deal with the evolution of the law.
Yeah, as the law expands, then the judicial officers who are required to administer and enforce it and apply it are going to be, their already full plates are overflowing. So we're going to need more plates at the table if we're going to have more torts for them to adjudicate. Anyways, it goes to show you that if no one is above the law, then everyone is beneath it. And also that the law is ever expanding. So you will be beneath more of it as we go forward and the courts continue to recognize the changes that are necessary to govern our society. So thanks again, Stephen. A great topic, great discussion, and always interesting to talk about where the law is taking us as we speak.